Hi, hello. Good afternoon. Good afternoon, everyone. Good afternoon from Chicago. And thank you all for joining us. I'm Filippo Lancieri. I'm a postdoctoral fellow at the ETH Zurich Center for Law and Economics and a research fellow here at the Stigler Center. And this afternoon, we are very happy to host a conversation over lunch with the chair of the Federal Trade Commission, Lina Khan, and Booth Professor Rolnik. We are particularly delighted that Chair Khan was able to join us. We had the pleasure of hosting her as a speaker at 2017 and 2018 conferences. In 2017, she was still a third-year Yale Law student. In 2018, she was then director of open markets. Now we can host her as 2022 as a keynote. It's really a powerful testament to the changes and the speed of the changes that have taken place in the antitrust world and US antitrust policy over the past years. So before we begin, please note that we are on the record and live streaming, and we also post this event video on the Stigler Center YouTube channel later. This program will not include a Q&A audience session. As usual, the views expressed by our guests are their own and not those of the Stigler Center of the University of Chicago. And we hope that you'll be able to join us for more upcoming events, so please check our website for more details, as well as the Stigler Center's publication on promarket.org and capitalism. And now let me just briefly introduce our speakers. Lina Khan was sworn in as the chair of the Federal Trade Commission in June 2021. And as I mentioned, prior to the FTC, actually she was associate professor of law at Columbia University. And she has served in many different positions, such as counsel to the House Judiciary Subcommittee on Antitrust, Commercial and Administrative Law, legal advisor to the FTC Commissioner Rolnik Chopra, and legal director at the Open Markets Institute. Rolnik is a clinical professor of strategic management at the Chicago Booth, and one of the idealizers and organizers of this conference from the very beginning. He has over 30 years of experience in financial journalism, business, and politics, among others. And at Booth, he teaches classes on the political economy of regulation and the news media, among others as well. So now, without further ado, I'll give it to our speakers. Please welcome me and introduce them. Please try to welcome me.
Yeah. Thank you very much, Filippo. So, for the benefit of people who haven't been online in the last few hours, and specifically Chairwoman Khan, she just landed in O'Hare, and I guess with the concentrated airline system that we have in the US, the Wi-Fi is not that great usually. So I want to update you on a headline in Bloomberg this morning. There is a story about antitrust, and there is, with a photo of Chairman Khan, and the headline is that alarming that Biden antitrust cops, with the photo of Lina, are alarming M&A players with their terrifying rhetoric. So before we begin, first of all, I know Lina for 6 or 7 years. I never find her terrifying, but we'll see. And just to set the expectation, in this room, we don't have a lot of M&A lawyers, and in the spirit of Chicago School, we really expect from this conversation some terrifying rhetoric, so it's totally fine with us. So as Filippo mentioned, the first time you were here in this actually very room and building, it was March 2017. Okay, 3 months before you graduated. And the title of that inaugural conference was, do we have a problem of concentration in the US? So today, I think, correct me if I'm wrong, that in DC and in most capitals of the world, this is not a question anymore. But if people would have told me in March 2017, what are the chances that in 2022, we'll be hosting here Lina Khan as the chairwoman of the FTC. My answer would probably, the chances are near 0. So to kick off, Lina, can you explain to us what happened in the last 5 years? How did we get this takeover of the Khan, Kanter, and Wu partnership over Washington?
Well, first of all, to say it's so great to be back here and such an honor to be here with you. And I don't think you would have been alone in making that wager. Look, I think it's a remarkable moment. And the speed and magnitude of the change that we've seen over the last few years is something that I expect historians to be studying for many, many years to come. There are a whole set of factors that I think contributed, but at the end of the day, I think the change is being driven by a deep recognition that something has been awry in how we've been doing antitrust, and that how we've been doing antitrust has resulted in, say, a farmer being dependent on a single meat packer and the whims of that meat packer for their livelihood, or a parent having to ration their child's insulin, that those types of problems in our economy are connected to the decisions that are being made in the FTC and the DOJ. And I think that basic connection of the dots is something that I think we've seen become much more vivid for people. I think, I'd be remiss if I didn't acknowledge the important role of many people in this room in drawing those connections, in showcasing the deep problems in our economy and connecting them to how we've been doing antitrust. And I think this conference in particular played an incredibly important role, including back in 2017, because I think at that point, the Stigler Conference did a couple of things, right? One was it said, let's ask the question and let's look at the evidence. And when we say let's look at the evidence, let's broaden our aperture and say move beyond just I/O and look at a broader variety of methods, a broader variety of disciplines. Let's look at what the labor economists have been saying, what the macroeconomists have been saying, and what the non-economists have been saying. And I think the kind of fresh look at the evidence at that moment in time was incredibly important. I also think that Stigler as an institution gave credibility and respectability to a set of questions that even in that moment in time were not seen as respectable. And I think, it's really important for disciplines to be able to have that healthy type of self-reflection, but I think antitrust over the years had kind of settled into a type of end of history moment, where there was a sense that the kind of deep contestations and the deep debates had kind of settled and been resolved, and now there were questions, important questions, but they were mostly at the margins. There were some exceptions to that, right? So Bill Kovacic, even back in 1998, predicted that there would be a swinging back of the pendulum. But I think overall there had been kind of a distance from the more existential questions for the field, and I think Stigler did a lot to refocus and say, no, these are legitimate, important, credible questions for this field. I'd also be remiss if I didn't acknowledge the incredibly important role of Congress, of lawmakers. I think something that we saw coincide with the period of deep retrenchment over the last few decades was Congress becoming more of a backseat player in antitrust. And I think we've seen remarkable work by lawmakers across the political spectrum to deeply study the problems in our economy, to start educating the public about those problems, and to start introducing a remarkable series of bills and proposals. And so I think those are some of the factors that contributed. I think, again, though, this is something that's going to be continued to be studied for some time.
All right. So in your writing and your research in law school and in open markets, you sort of started to develop a theory of what happened to antitrust in the last, 30 or 40 years, why antitrust enforcement had declined. But now that you are almost a year at the helm of the FTC, or down in the trenches, really have to deliver and on those promises, has your perspective on what happened to antitrust has changed?
I think the basic story remains the same. I think there were a set of policy changes and policy choices that were made that led to significant retrenchment in how we do antitrust, and that's contributed to a whole set of harms. I think, on the ground floor, you see a whole set of realities at the institution in terms of the severe mismatch between the job that Congress has given to the agency and the set of resources that it has available. By some metrics, the staffing at the agency is lower now today than it was back in 1980s. I think for a place like the FTC, there's also a way in which the ghost of the 70s can loom large in the building. There's a very standard account that's often given of what happened in the 70s and what to learn from it. And it goes something like, here you had this agency, it acted boldly, it tried to do a lot, and that triggered enormous political backlash in ways that led to efforts to defund the agency, and that's a cautionary tale for us where we really need to be, focused, under the radar, doing our job, but not rocking the boat too much. And I think, it's worth it's worth, of course, learning the lessons from that period, but I think every moment has a different mandate. And I think in the same ways that kind of antitrust enforcers talk about, type 1 versus type 2 errors and the costs of action and inaction, I think we kind of need to have that conversation at the institutional level as well, where decades of actual under-enforcement has severe institutional costs as well. And so I think kind of rebalancing how we do the analysis, because I think, inaction means that Congress can start seeing you as irrelevant. The public can lose faith in institutions, and that can also lead to certain types of neglect in ways that have deep institutional costs. And so I think kind of rebalancing how we think about the trade-offs between action and inaction, and realizing that there are severe costs to under-enforcement and inaction, I think is something that just within the building is something that we are thinking a lot about as well.
So you and your friends in this movement can definitely declare a victory in changing public and political sentiment towards concentration and monopolies, but it's still not clear if you have the ability to apply those ideas. So how do you think about defining a victory or victories at this particular moment in time?
Yeah, I think this is an incredibly important question and one that I think a lot about. I mean, I think at the end of the day, the task for the antitrust agencies is to make sure that the people know that we're here to fight for them, that we're here to enforce the law, and perceptions that people might have had that the agencies are not fully in their court, not fully fighting for them, not actually taking on the fights that matter. I think that's something that needs to change. I think at a more practical level, there are a whole set of factors and constraints that are outside of our control as agencies, right? Our level of resources, how any particular judge might apply the law, but there are also a whole set of policy and tools and procedures that are within our control. And I think what's important for us to be doing is inventorying those and translating some of these bigger goals into the tools and factors that are within our control. And so one area where we've been doing that is in the merger context, where over the last couple of years, we saw a huge surge in merger filings. The agencies were totally swamped. And so we've been taking a close look. There are a whole set of factors like the 30-day timelines within HSR that are very difficult. And the state of the law, which can make it difficult to bring certain types of cases, but there are also factors within our control, right? So for example, the type of information that we're requesting from merging parties on the front end through something called an HSR form, which today is mostly collecting information, as AAG Cantor puts it, to figure out if there's compliance with HSR or not. Less probative information for us to figure out, is this an illegal merger? So being able to actually adjust, what information is being collected when parties are trying to merge is something that can seem, kind of arcane, but can make a very big difference. We're also, in tandem with DOJ, undertaking a revision of the merger guidelines, basically asking two big questions. One is, how do we ensure that the guidelines are reflecting modern day market realities so that there's not as much of a gap between how markets are actually working, how businesses are actually strategizing, and how the guidelines are assuming that they do or don't. And the other is to make sure that the guidelines are accurately reflecting the state of the law. It's not appropriate for the agencies or for the guidelines to be offering a more cramped, restrictive conception of what the law is than what Congress has articulated or what the courts have articulated. And so those are two areas where we think we can make a difference. We at the FTC have also been taking a close look at merger settlements. Are these settlements working? Are they effective? How can we, for example, through the use of prior approval, make sure that companies are not repeatedly engaging in the same types of unlawful transactions? So that's just one example of where we have a big picture goal to be deterring unlawful deals, to be stopping unlawful consolidation, and we're kind of doing an inventory of the tools that are within our control to kind of map out what we can do to make a difference.
So there was a ton of discussion here this morning and yesterday about what's going to happen with the courts. Are courts going to be a significant barrier to your new agenda? But, the way to maybe summarize it, I think, is that AAG Cantor yesterday said that he's not worried as much about losing cases because he's not a member of the chicken shit club. This is, of course, referring to Jesse Eisenger's wonderful book, because prosecutors also need to and should fail. Do you think if you lose multiple cases but still convince the public or maybe legislators that there needs to be a legislative change, you are still winning? Do you subscribe to this?
I'm certainly not somebody who thinks that success is marked by 100% court record. I think we need to be, as public enforcers, we have a special obligation to be bringing the hard cases. I think it's also really important to be having the institutional dialogue among the three branches. So if the antitrust agencies look at the market, think that there's a law violation, think that the current law might make it difficult to reach, there's huge benefit to still trying, especially with trying with some of the bigger companies, some of the more high-profile cases. Because if you don't try, the message that sends out to the world is that the enforcers don't think there's a problem in the market. Whereas if you try, even if you lose, that then creates the message for Congress to know, hey, here are these law enforcers, they recognize there's a problem here, the current law is not adequate for them to reach it, and so let's change the law. And I think that type of institutional dialogue among the three branches is incredibly important, and if instead as enforcers you think, these are really hard cases, we recognize that there's enormous risk with bringing them, we don't want to make the law worse, and so you just never bring those hard cases, I think there are severe costs to that can lead to stagnation and stasis.
So let's talk about it more. So you have a very, what I think is an ambitious agenda and limited resources, or even maybe limited time considering what might happen in politics. So maybe one of the ways to consolidate gains is by creating real deterrence in the market. So how do you determine which cases that you pick are worth fighting, because winning them will send a strong message to the market?
Yeah, it's an incredibly important question and one that we've been giving a lot of thought to, given the limited resources and given the importance of promoting deterrence. Oftentimes, we're just looking at where is the most harm happening. Oftentimes that involves some of the biggest companies and the biggest players. I think one area where we've seen success is in our merger enforcement work, where over the last few months we've seen significant victories, including in the context of vertical mergers. So the FTC challenged in the last few months both the NVIDIA ARM merger and the Lockheed Aerojet merger, both vertical transactions. In both instances, the parties ended up abandoning, which is enormously significant if you think about how even a few years back when the DOJ challenged the AT&T Time Warner merger, the kind of atmospherics around that was quite radical. The antitrust agencies hadn't brought a vertical challenge in many decades. They ended up losing there, but I think the fact that we've gone from that outcome then to now instances in which the FTC filing a complaint in these vertical challenges are leading companies to abandon, I think shows remarkable progress. I think also the fact that we challenged Lockheed Aerojet in particular sent a very strong message in the defense industry, where for years the approach has instead been to allow the consolidation to happen, to accept settlements and remedies that in hindsight I don't think have been as strong. And so I think being able to take that type of action ended up sending an important message that we're not going to be settling for weak remedies. There are some deals that are illegal and can't be remedied, and in those instances, they need to be blocked.
Mention AT&T. I think that was a really tough case probably for agencies, given the fact that, correct me if I'm wrong, just before the agencies filed, the president said about this merger that he doesn't like the programming of CNN. So there was some political notion tied to it. So you and, going back to terrifying rhetoric, so you and your colleague, A.G. Cantor, believe that it's time to go back to criminal investigation and enforcement. I know this is the DOJ's purview, but probably your attitude towards it will also carry a weight. Do you think that agencies should, pursue more criminal investigations and maybe even name names of executives when they are suing companies?
Yes, absolutely. Last fall, we took some steps to strengthen our ability to more regularly and routinely refer criminal cases to the Justice Department, so that's something that we have underway. We also recently had great success in actually naming an individual in one of our antitrust cases, Martin Shkreli. So this was a case that was initiated under my predecessor. In the fall, we ended up settling with a whole bunch of defendants, but ended up deciding to actually continue to go to trial on the case against Martin Shkreli personally. And we ended up getting a terrific outcome in January, where we ended up getting a lifetime ban on Shkreli from the pharmaceutical industry, as well as a whole set of additional relief. So I think naming individuals is incredibly important. I'd also be remiss if I didn't recognize here the work of former commissioner, now CFPB director, Rohit Chopra, who has, I think, given an enormous amount of thought to how you deter lawbreaking, and in particular, how you craft remedies to deal with recidivism. He gave an incredibly important speech a few weeks ago at Wharton that kind of lays out some additional tactics, and I think that type of worldview is also informing how we're looking at these things.
Okay, so I want to build on those remedies. So beyond the fines, that many people see as just, and many companies probably see as just cost of doing business. Even if it's a $5 billion fine, we see the stock of Facebook goes up. Do you envision more remedies that have been in the FTC and the DOJ's arsenal, but were rarely used? You said that Martin Shkreli was banned for life from pharmaceutical. Do you think that on top of structural remedies or governance remedies, at some point you will see agencies, let's say, banning Mark Zuckerberg from going on social networks, or limiting his screen time?
Yeah, I mean, look, I think the industry ban we were able to secure in the Shkreli case is enormously important and somewhat precedent-setting in the antitrust context. I think, the way I think about remedies, and the traditional way to think about remedies, is there are at least three goals, right? The immediate goal is to stop the illegal conduct and to stop the recurrence of that conduct. A second goal is to cure the harm that's occurred through the underlying illegal conduct, the harm both to the market as well as to the victims of that conduct. And the third is to really, disincentivize further lawbreaking. And so on each of those prongs, we're thinking about how we can be more effective. On the first, stopping the lawbreaking, I think we need to act in a more timely manner. We need to be going into court more quickly. We need to be seeking preliminary injunctions. On the consumer protection side, the FTC a few weeks ago filed a lawsuit against TurboTax on the consumer protection side, alleging that TurboTax had been showing all these ads that are allegedly deceptive, and that it was really important to get that relief ahead of tax day. But I think that type of timely intervention and timely filing of lawsuits is incredibly important. I think thinking about how do you actually cure the underlying harm is incredibly important. There's this really terrific quote from Justice Robert Jackson where he says that the goal of antitrust lawsuits must really be to pry open the competitive market that had been closed shut by the illegal conduct. And I think thinking about how you actually do that prying opening of the market, especially in the context of, say, some of these digital markets, is incredibly important, where you need to make sure that some of the illegal gains that were obtained through the illegal conduct, certain types of data, certain types of scale, that were achieved through, basically determining that unlawful conduct was worth the cost of business because it might help you tip the market or achieve greater market share. That those are types of, business strategies, incentives that we really need to be studying in order to be able to undo the harm. And similar with, making sure that the victims of that conduct are fully compensated. And then the third prong, thinking about how we should be disincentivizing lawbreaking to begin with, I think gets into the category of, preventing recidivism, thinking about the structural relief, the relief with regards to individual executives, governance level changes that are incredibly important as well.
Okay, so ahead of this conversation, I'll be talking with some people in DC, and we talked a lot about power imbalances this morning here, usually between companies and consumers and other stakeholders. But I want to talk about the power imbalances in regulations. So someone in DC told me this week that the battle between regulators, okay, and this is you and big tech, and this is now what, it's not only big tech, but big tech are the largest companies. In that battle, you are Ukraine, okay? So you may have popular support, but Russia is much more powerful. Do you feel that this is a way to describe the power imbalances between regulatory agencies and big private sector?
Look, I think there's no doubt that we have enormous political support and public support. And I think there's a real sense that the cause that the agencies are taking up is righteous and it's important and it's in many ways, critical to the fair functioning of our economy, but also ultimately of our democracy. There's no doubt that there are severe, resource asymmetries between the enforcers and these powerful companies and the very well-heeled lawyers that they're able to hire. And I think, similarly, we need to be playing to our strengths and identifying, what are some of the tactical advantages that we might have. You're not going to try to go, toe-to-toe based on, based on trying to match resources when you just don't have them. You have to be able to play smart. And so I think that type of inventorying of what are the tools and tactical advantages that we might have, how do we do things like, bring cases more quickly, not fall into some of the traps that lead to, years long of settlement discussions without quick action. I think those are the types of, advantages that we need to be thinking about, as well as, continuing to do a full assessment of the tools, including those that might not be being used. But I think it's certainly true that if you try to go toe-to-toe with some of these companies based on their terms, that's only going to be disadvantageous. And so thinking about the comparative advantages we might have is something that both DOJ and we are doing quite closely.
So Cantor talked yesterday about he talked about 5 pillars, and he said the second pillar is that we didn't engage enough with the public. We were just in those silos talking only with the experts. And my question to you, assuming that you share this idea, is how do you convince at this time and age of polarization, identity politics, and culture wars, how do you convince the average American that FTC and DOJ policies and actions are very important to their lives?
Yeah, it's a great question, and I think in many ways that work has already been done. I think there's already wide recognition that the decisions that are being made in these buildings have enormous consequence for the way in which people experience power in their lives, whether people do or don't have access to affordable medicines. I think we've been doing a few things at the FTC to make sure that we are encouraging and enabling more participation. We've started to do these open monthly meetings where we have items on the agenda, but we also have a portion of the meeting where people can just sign up and come speak to us, come tell us about problems that they're seeing in the marketplace, problems that they think should be on our radar. And it's been really terrific to be able to hear regularly from people who are not in Washington, D.C. about the types of problems that they're seeing in marketplaces. We are government officials, we are public servants, we serve the public, and so we need to very actively be listening to the public, learning from the public, and I think those type of forum have been really incredibly important. As we do the revision of the merger guidelines, we've also been doing these listening forums where we are inviting market participants that are not the types to be able to hire law firms to write the 100-page submissions to the agencies, but really have deep expertise from their own day-to-day experience in these markets to be able to share with us what they're seeing. So a few weeks ago, we did one focused on the healthcare industry, where we heard from physicians who could attest to the effects of private equity roll-ups of physician practices. We heard from nurses. We heard from independent pharmacists, as well as from patient advocates who could share with us their real-world experience having lived through mergers and acquisitions and the types of harms that those have been created. So I think some of this work is already being done, and people are already realizing how the kind of day-to-day realities that they're living connect to the decisions being made by antitrust enforcers. But I think there's certainly a lot that the agencies can also be doing to actively encouraging and welcoming that type of regular public input. And it's something that's incredibly important to me, and I think we've already seen some great success with in terms of being able to shape our work based on what we're hearing. So some of the the most significant input that we've gotten at our open commission meetings has been from patient advocates, people in particular who've come and talked to us about the way in which the price of insulin has surged over the last few years in ways that are leading people to ration their medicine, oftentimes leading to bad health outcomes, even death. We've also heard a lot from independent pharmacists who have been alleging that the practices by the pharmacy benefit managers are basically squeezing out the pharmacies. So a lot of the input that we received there has basically gone into shaping a study that we hope to be able to do on pharmacy benefit managers, as well as internally how we're thinking about some of our enforcement strategies. So we're really expecting that there's going to be a feedback loop between what we're hearing from people and how that's directly informing our work.
So some of the things that you mentioned right now actually are maybe out of the purview of antitrust. And I know this is a conference that we focused mostly on antitrust, but I want to take this opportunity and ask you about the consumer protection role of the FTC, because when I follow your activity in the last 6 or 9 months, I think I see that your views on antitrust might be also reflected in the consumer protection role. The agency is suspicious of this model that consumers have really have free choice, even if it looks like as if we have competition, and perhaps you and your team see that in many industries, competition is maybe a mirage because of asymmetry of power, information, sunk costs, switching costs, or sometimes even, to quote one of the Nobel laureates, where what we see is a competition in who is better in deceiving or addicting a consumer. So we're not really talking about choice. It looks as if there is choice, but it's more of a coercion.
Yeah, that's exactly right. I mean, I think the way in which our consumer protection laws are structured, they basically give the FTC authority to police unfair or deceptive acts or practices. And what that means in practice is that the law really thinks that the ideal state of the world is that you have well-informed consumers that are acting rationally and that are making free choices in a marketplace, and really police for instances in which that ideal version of the world is not happening. One the common area where the FTC enforces here is when there's active deception, right? So if there's active deception, consumers are not able to make free choices in the marketplace. But I think you're absolutely right that short of outright deception, there are also a whole set of ways in which users are not able to actually exercise free choice. And we've been doing work internally to kind of create a taxonomy of what some of those instances are. So one thing that we increasingly say is dark patterns or kind of manipulation. So the ways in which you structure choices in how you're displaying choices to people really nudge them in certain directions in ways that is ultimately manipulative and shouldn't be read as them exercising free choice. I think another thing that we see, especially in instances where you see asymmetry of power, but also deep dependence on certain types of services, the people are not actually making choices, right? So one thing that we've seen is as the pandemic has hastened dependence on certain types of technologies, including children having to use, educational technology tools to be able to do their homework, that parents, when presented with the choice of, in order for your kid to be able to do homework, you have to sign away certain data protection rights that they have. You have to basically allow them to be surveilled over an indefinite period of time. A parent in that situation is not really exercising free choice, right? That the set of choices before them are not ones where I think we can fairly say that the parents are actively choosing surveillance here because that's something that they prefer. And so I think those are types of instances where we're really trying to scrutinize what are the underlying realities of these markets such that we are able to more effectively target instances where people, as you put it, are being more coerced or deceived rather than exercising free choice. The unfairness prong of our Consumer Protection Authority is incredibly important, and we're taking a close look at that to identify what are ways in which we might have been looking at some of these areas quite narrowly. So, for example, there's a three-part test in how you think about unfairness. One of those is focused on this idea of substantial injury, which traditionally has mostly looked at monetary harm, harm to health or safety. We're starting to look at are there certain types of privacy harms or dignity harms or other types of harms that we really need to be also focused on, as well as additional opportunities within some of these existing legal tests to really be more assertive.
So you mentioned dark patterns, and I read something that you said last week, that you said we need to, this paradigm of consent on the internet is outdated. So can you tell us how would a new paradigm look like?
Yeah, it's an important question, and one I think that lawmakers in particular have also been grappling with, where the only we don't have a federal national privacy law. What we've seen is sector-specific privacy laws as well as increasingly state-specific privacy laws. For a long time, the kind of dominant paradigm has been what's known as notice and consent. So the idea being that if firms give you notice about how they're going to be collecting or using your data, and then users are in a position to be agreeing to it, that's somehow sufficient to be policing how companies are using and potentially exploiting people's data. I think what we've seen is, again, as some of these tools and services have become essential for navigating everyday life, I don't think it's reasonable to think that this type of notice and consent structure is still adequate. Again, because people oftentimes don't have any choice but to sign away these rights. And so I think that really compels us to think hard about what other types of limitations we might be placing on certain types of data collection to begin with. I think Europe's experiment with GDPR has been enormously informative and instructive, where there have been thoughtful assessments of whether the types of procedural rights and protections that are provided, where basically if parties jump through enough hoops, that's what's necessary in order to be able to collect and process data, whether that's really sufficient or whether we really need to be just setting more bright line rules and limitations on how data is collected. A lot of this shift could come from Congress if Congress ends up legislating a privacy law. The FTC also has rulemaking authority, including on the consumer protection side, and there's a lot of public interest and support for us thinking about how we might also craft rules within the FTC to be addressing some of these issues as well.
So you were not here this morning, and so Luigi started this tradition here of awarding royalty and monarchy positions, and so the question is that was very time and again, if you were queen for a day, or if you were queen for a, so the question is, if you are the queen of antitrust and you get to do what you want, tell us what is the criteria of decisions you're going to make in decisions when it comes to antitrust issues. You're not bounded now by the current laws and norms, and you can do whatever you want.
Seems like a very dangerous question for a law enforcer to be engaging in. Look, I think there is a really healthy and important debate right now around the types of reforms that we need, including on the antitrust front. I think looking at the types of problems that we're seeing in the marketplace and figuring out where are the areas where things have gone awry is incredibly important. I think greater reliance on presumptions and bright line rules, making sure that it's easier to enforce the laws, is incredibly important. And I think the fact that even on its own terms, some of this kind of consumer welfare-focused approach has failed, right? We've seen all these reports suggesting that markups are so much higher. I think also begs a lot of introspection around, where things went awry and how we can make sure that the laws are clear, they're providing fair notice to all market participants, and that it's easy to enforce, and really addressing ultimately the underlying goals and values that Congress had in mind when passing these laws against the backdrop of the Gilded Age, the Industrial Revolution, these deep concentrations of power. I think it's increasingly acknowledged now that the way we do antitrust has become unmoored from those foundational values and principles, and I think we need a corrective there.
So building on that, so one of the issues that we discussed here a lot today is this, maybe, is there a trade-off between efficiency and democracy? And like if you are a hardcore new Brandasian, you think about what the most important thing is democracy. If you are more moderate, then you think about trade-offs with efficiency. Where do you stand on that?
I mean, I think as a law enforcer, we have to enforce
How do
the
you
laws
interpret the
as
law?
written.
Yeah.
I think there's the word efficiency doesn't appear anywhere in the antitrust statutes, right? They're really written in the FTC's case, to allow the FTC to police unfair methods of competition. Implicit in that prescription is the idea that there are illegitimate forms of competition and legitimate forms of competition. And it's really up to the FTC to be defining what is fair and what is unfair when it comes to competition. It's not that any business practice that increases welfare or increases efficiency is fine. It's really this conception of unfair methods of competition. And so I think embedded within that is a task for the agency to be defining that. There's a lot of interest right now in having us think about the proliferation of non-competes in labor contracts. I think we hear a lot of arguments from firms around why those might be efficient in terms of enabling investment, and enabling training. I think we've also seen trade-offs in terms of the type of restrictions that they place on workers' liberties. I think that's a site where you see some of those arguments made, but I think ultimately, even within the language of the antitrust statutes as established, we don't see some type of preference given to efficiency over democracy. It's really focused on competition, and in the FTC's case, unfair methods of competition.
So building on that, one of the issues that was discussed here again was the question of bigness per se. And I think it was Fiona Scott Morton who said maybe, okay, if we think we have a problem with that, so maybe we should have laws on the book that limit once you get to $1 trillion market cap, we break you up. So how does the FTC, given the current laws, we don't have new loans, view bigness per se? For instance, a very large conglomerate goes out to buy a large operating company, and on the face of it, there is no horizontal or vertical issues here. But yet we see $1 trillion, $2 trillion, $3 trillion company gobbling up more and more companies in other industries. How do you view that?
I mean, I think on the first question, there's no doubt that indicators of concentration, consolidation, size, those can be oftentimes proxies for market power, and where market power exists is where market power can be exploited and used in unlawful ways. So I think focusing on the areas where we see some of the most significant incumbents, where instances in which they've been able to maintain dominant positions over a long period of time, I think that can often be a fruitful area to focus. I think this question of conglomerates is incredibly interesting. I think there was a really robust discussion and engagement with conglomerates, back in the 60s and 70s, where the agencies were thinking about law enforcement theories, what happens when you see this type of conglomeration, what should antitrust and merger law in particular have to say about it. Some of those discussions then fizzled out because I think we saw, certain diseconomies of scale that hit, and we saw, just the dissipation of the traditional industrial conglomerate back in the 60s and the 70s and 80s. I think what we now see, especially in the digital context, is that those diseconomies of scale don't hit in the same way. They either hit at a much later scale, or just, might not come into the picture at all. And so I think that really invites us to engage with this conglomerate question. We might not think it's worth calling conglomerate. Maybe some of the dynamics are a little different, but the types of instances where we see individual firms establish positions across markets, across sectors, I think invites scrutiny. I think one thing that we're trying to do with the revision of the merger guidelines is to determine, what should we as enforcers be thinking about when we encounter situations like this, because I think it's, as of right now, a somewhat understudied topic in the context of our new economy.
So what do you think is the role of antitrust, another thing that we discussed early this morning, when it comes to, is there a role for antitrust when it comes to labor relations?
So I think there's no doubt that we've seen a lot of incredibly important work showcasing how labor markets across the U.S. In certain instances are highly concentrated, that level of concentration has had very material effects in terms of wages being depressed, wages being stagnant, types of anti-competitive agreements among employers, such as no-poach agreements can have enormously detrimental effects and be per se illegal. And I think it's the job of the antitrust enforcers to be enforcing the law even when the harmed market participants are workers, are laborers. And so I think both the DOJ and FTC have made significant progress in this area over the last few years. I think the work that the DOJ has been doing in the context of no-poach agreements and bringing criminal cases is incredibly important, and I think shows that there's gravity of harm there that we really need to be recognizing. The FTC, in one of the recent merger cases that they brought, blocking a hospital merger in Rhode Island, my colleague Commissioner Slaughter and I noted in our separate statement that the staff had actually investigated the harms to healthcare workers that would have occurred as part of that transaction, and we would have supported including a count in the complaint that would have recognized this harm to labor. So I think we still have more to do and more to learn about how do you translate the concern about labor and the harms of anti-competitive conduct on workers to our enforcement strategies, but I think we're already seeing important benefits there.
So earlier you talked about the importance of promptly acting fast from lessons from mistakes that we've done in the past. So I know that at this particular moment, economists and other people are still not certain about what's happening with this wave of inflation, and does it have to do with antitrust. But this morning I saw an economic analysis about this inflationary waves, and according to that analysis, corporate profits increased in this wave much more than in previous waves of inflation. Is this something that you are looking into?
Certainly, I think we as an agency have a responsibility to understand, what might be the role of market power or anti-competitive conduct in the current inflationary environment that we're seeing. CEOs have been boasting on earnings calls that the inflationary environment gives them power, gives them cover to be exploiting market power, to be increasing prices, and so that's certainly something that can raise a whole set of legal concerns, including such as potential invitations to collude, instances in which firms might be using these earnings calls as a way to kind of signal to their competitors certain types of strategies. So that's certainly something that's relevant. I think, stepping back, we also need to be thinking about the ways in which lax antitrust enforcement or focusing on efficiency over considerations like resiliency has contributed to the brittling of our supply chains, such as what we're seeing now, where certain types of shocks to the system mean that we're not able to respond as quickly, we're not able to be as resilient, and so you're seeing the types of supply disruptions that are also contributing to the inflationary environment. And I think thinking about the role of antitrust, in particular merger enforcement, as part of that is also incredibly relevant.
All right, so we have a hard stop in 2 minutes, so I'm going to give you, the last question is, I'm going to give you 2 or 3 minutes to answer that. So I hope that next year when we convene here again, hopefully, you will be here again to answer some questions. Can you offer us a meter to assess your success in 2 years' time, 2 years at the helm of the FTC?
Well, I mean, I think it goes back to what I said earlier. Are these agencies that are really showing the country and showing the public that we're willing to take on the fights that matter, the big fights? I think, again, that's not always going to translate into universal victories in the courts. But I think it's certainly a mandate that we feel. I think these types of windows of opportunity where there's deep public hunger for change create enormous responsibility for us to respond and act. And I think that's going to be an important metric for us.
Chairwoman Khan, thank you very much.